So I heard there's some discourse about the Idaho documents and why some things are redacted and some things aren't being released. And I think if you're going to have a conversation about this, you should probably take it from someone who actually works in the criminal courts, is an actual attorney, and has dealt with the issue of redactions before. So just to remind you guys, I'm Stephanie. I'm a criminal defense attorney. Been doing this a long time, and I've been paying attention to the Idaho case since literally A1 day one. Like A1 day one. Not doing this for clout, not doing this for attention, just doing this to clear some things up that are being falsely spread on the internet. Now, when it comes to redactions, the court has a right to redact the things that they feel are sensitive in nature, right? It could be done on the application of a moving party. It could be done on the application of the court. It could be done on the application of the defense. It could be done on the application of the prosecution, right? So specifically here, we're talking about, like, let's say bare bones, last name, social security number, phone numbers. You guys don't need that. And I would think it would be weird if you guys were like, I want all this information, including last names, date of birth, and social security numbers. I think that would be weird if you want that stuff, because why do you need that information about people who are unrelated to the case? So moving on to that. And the reason for that is because they don't want you doxing them. They don't want you people going after people and, like, also possibly assuming your identity, especially given the nature of the people who are obsessed with this case, who have histories of scamming. I wouldn't trust the social security numbers, date of births, and last names of some of these people with those people. That's wild work. Now, moving on to the other stuff, like, let's say the toxicology reports. The toxicology reports you're not getting because they're irrelevant to the case. What those victims drank or did that night does not give a justification for why they were unalived. It doesn't give a reason for why they were unalived, and bears no actual weight to the case at all, because they are college students and they do things that perhaps they shouldn't. I certainly did things in college that I would not want my toxicology reports to be shown to anybody, but in the end, this case has nothing to do with narcotics. There's never been any evidence that this has to do with narcotics. And if you cite to me that they found a rolled up dollar bill and crushed up shit in their rooms, I'm going to refer to you that everyone in college, not everyone, a lot of people in college tend to experiment. And then you're going to say, well, their parents have histories with narcotics. And I'm going to say, were their parents unalived? Were their parents in the state? Were their parents there that night? And the answer to those questions is no, because their parents have nothing to do with the criminal case that was pending against Bryan Kohberger. Everything isn't one of those crazy little serial killer maps with the red strings that you get to connect to come up with some conspiracy theory. You're not entitled to know what was in their system that night. Those will stay private, because that's none of your business. Okay, the court is allowed to not release those because it is a sensitive topic and irrelevant to the case. The court is allowed to protect the victims. The court is allowed to do that. That is a valid redaction, and it's valid of them to keep that from the public. As for interviews, sealed interviews, if there is sensitive in nature information in said interview, they are allowed to redact that or hold that back legally. Because if releasing that would harm someone or be a danger to the public, they're allowed to keep that to themselves. It's a case-by-case analysis. They evaluate every piece of evidence and make a determination if releasing that information to the public would harm an individual, cause them distress, whether emotional, mental, physical. They are allowed to keep that information from the public. That is standard practice in criminal procedure law in every state in the union. This is not special just for the Bryan Kohberger case. It happens in every case. Literally every case. I have gotten witness statements where half of the page has been redacted before. Grand jury minutes. Half of the stuff is redacted. It's not because they're being shady. It's because they're allowed to do it to protect the individuals who are testifying, to protect the victims, to protect the surviving victims. They're allowed to do it. Now, if you want more clarity on this, I certainly can give it to you. But if you're going to pay attention to anybody who's talking on this subject, possibly pay attention to someone who actually does this for a living. Just a thought. I hope that clears things up. If it doesn't, we can make more videos. But if not, we're good to go. Have a great day. Bye.